Hello friends. Uh, Today this video which I am making is to impart a very important message to all my colleagues who are doctors and the hospital owners, that whenever a honorable court issues a summon or a notice to you, why it is very important to reply to that message with due diligence in the form of a written statement with the help of your lawyer and your medico legal consultant within the stipulated time, which according to the Consumer Protection Act is within 30 days, and with the special permission of the court is up to 45 days. Now the case, I'll be discussing a case which was adjudicated recently in 2025. The case was instituted in 2001, where a young person who suffered some accidental injuries had gone to a hospital, was taken to a hospital in Mirzapur. He suffered injuries on his thigh and the face, and from where he was referred to Banaras in a bigger hospital, where he underwent the surgery, but unfortunately couldn't be saved. So in 2001, the parents of the deceased patient instituted this complaint against the hospital, both the hospitals where he was treated as well as the institute where he got injured. It was a teaching institute, and they were given the notices by the state consumer court in Lucknow. So the initial hospital where the patient went, they filed a reply in the Honorable State Consumer Forum, as well as the educational institute where he was injured. They also filed their reply with their lawyer. But the main hospital where he was operated and where he died, they didn't file a reply within the stipulated time. So in the order of the Honorable State Consumer Forum, which came in around 2007, the Honorable State Consumer Forum absolved the first hospital and the educational institute of any negligence, but held that the main hospital where this patient was treated did not file a reply to the notices of the State Consumer Forum, and hence on this point only that hospital was found to be guilty of medical negligence, and court awarded a sum of around rupees 13 lakhs 12 lakh 92,000 with 10,000 litigation cost to be paid with 9% interest. So the point to discuss in this case is that when the Honorable State Consumer Forum had issued a notice to the concerned hospital B for filing their reply, and the main contention which the patient had filed regarding the issue of medical negligence was that when the patient suffered a cardiac arrest, there was no cardiologist available to resuscitate the patient. Now, as doctors, we all know that to resuscitate a patient, the mandatory provision of having a cardiologist is not there. So this could have been easily refuted with strong medical evidence, but the problem is that the no reply was forthcoming, and hence the State Consumer Forum had to award a decree against the doctor. Then what happened when they finally filed a request in the National Consumer Forum that they should be allowed to file their reply? The National Consumer Forum was kind enough to allow them to file their reply along with their medical evidence and the case papers. And finally, the National Consumer Forum Delhi adjudicated that there was no medical negligence as such in the duty of the hospital B where the patient was operated, but the hospital should have replied in the due time which is given in the act, and had they done so, probably they wouldn't have faced any penalty for this. But now that it has been 25 years, so they did reduce the amount of amount of money which the hospital had to pay for the compensation, but didn't totally cancel the amount. So the point here is that see, for doctors especially, we are very hardworking community and we are working day and night for the care of our patients. But when it comes to litigation, we do tend to sometimes ignore the important provisions of law. So whenever a doctor or a hospital gets a summon or a notice from any courts, especially the consumer courts, then we have to file our reply within the stipulated 30-day period, and we should take due care. We should sit with our lawyer or advocate or medical legal consultant, whoever is preparing our reply. We should back our reply with strong medical evidence as well as case laws. And if we do that, many times we would be easily be saved by the burden of paying such hefty compensations, because you see, all professionals can get such summons. It is not only the doctors, but as doctors we sometimes tend to ignore, and that is what I have observed. And if we do due diligence, a lot of cases can be easily dealt with. So that's my message for this case. Thank you very much.